So the Supreme Court just issued a 6-3 decision in a case involving a man who was found guilty of being a felon in possession of a firearm. So let's talk about this. But real quick before we jump into this video, I want to mention that we are currently approaching my 4-year anniversary here on YouTube. I want to thank you guys so much for all of your support, and also mention that right now kind of one of my goals is to try and reach 550,000 subscribers by that 4-year anniversary. So if you're not currently subscribed, please consider subscribing to the channel. But regardless, thank you guys so much for all of your support over these last 4 years. As I mentioned in the intro, in this video, we're going to be discussing how the Supreme Court this last week issued a 6-3 decision in a case which involves a man who was found guilty of being a felon in possession of a firearm in violation of federal laws, and that section is 922G1. The case we will be breaking down in this video is called Jones v. Hendricks. This is an interesting case because although it does not deal directly with the Second Amendment, the case does involve a challenge to the federal laws which deal with felons in possession of firearms, and also some procedural aspects that really had an impact on this case. It also deals with how the court must look at the actual text and history of statutes to determine what Congress intended to mean when they write specific laws. This decision also sets the framework where a pure constitutional challenge to that federal law 922G1 on prohibiting nonviolent felons from being in possession of firearms is now even more likely, or could be more likely, because of how this case played out. This case had a majority opinion authored by Justice Thomas, and then 5 other judges, mainly the conservative judges, joined in that majority opinion. Now, this case really hinges on some procedural nuances that I'm going to try to simplify to the best of my ability and just give you the bare bones of what you need to understand this case. Under 28 U.S.C. section 2255, a federal inmate is able to challenge their sentence or convictions. There are, however, limitations under the statute of how many times a challenge to that conviction can be brought. The limiting language essentially prevents multiple bites at the same apple, especially if you've already brought one challenge to that conviction. There are, however, 2 scenarios where the law permits a second or successive challenge to a conviction after the individual has already used up their one challenge. Under 2255 subsection H, the law says a second or successive motion can be brought only if 1. Newly discovered evidence that, if proven and viewed in light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that no reasonable fact finder would have found the movement guilty of the offense. So that's the first one. And then the second one is, or 2, a new rule of constitutional law made retroactive to cases on collateral review by the Supreme Court that was previously unavailable. That means that those are the 2 express situations in the statute where an individual can challenge the conviction on a second try, or essentially bring a successive challenge. But this case involved whether someone could bypass those 2 express limitations for successive claims and instead simply bring a writ of habeas corpus to get a second try at a challenge to the conviction. And really that complication comes from the same statute, which states that an application for a writ of habeas corpus on behalf of a prisoner who is authorized to apply for relief by motion pursuant to this section shall not be entertained if it appears that the applicant has failed to apply for relief by motion to the court which sentenced him, or that such court has denied him relief, unless it also appears that the remedy by motion is inadequate or ineffective to test the legality of his detention. So the language in that statute hints at maybe someone being able to bring a writ of habeas corpus and then being able to bring that challenge, and outside of the traditional 2255 motion, but essentially they have to prove that the traditional motion would have been inadequate or ineffective. Now in this case, the individual, Mr. Jones, argues that he should be able to file a writ of habeas corpus under that essentially limiting language, which was 2255 subsection E, saying that the challenge or the traditional motion that he could have brought would have been ineffective or inadequate because of the prior language that says that he can only bring one challenge. He argues that the motion would have been inadequate or ineffective, and therefore he can bring the writ because he already brought one challenge to his conviction. He won part of that challenge to the conviction, but the law has not changed significant enough where a constitutional law has been changed to where he can bring a successive challenge under that pure express language of the statute. So that's the basics of the statutory interplay that's at question in this case. I know that that's a little bit complicated, but that's the essentials that you need to know to understand what's going on in this case. Now, factually, Mr. Jones was convicted of being a felon in possession of a firearm in violation of federal law 922, subsection G1. But after his conviction, the Supreme Court ruled that under subsection 922 G1, an individual in question must have had actual knowledge that they are a person who's prohibited from being in possession of a firearm. Essentially, they have to prove, or the prosecutor has to prove, that you had actual knowledge of that fact. Mr. Jones originally was convicted under federal law, but under the prior precedent, that was not required. That was not a required showing. Now, after that Rahafe decision, Mr. Jones then hoped to use that Supreme Court decision to bring a new challenge to that remaining conviction that he did not get wiped out. But the argument is that Rahafe statutory holding in the change of law by the Supreme Court does not satisfy the section 922.55H's gateway conditions for a second or successive motion under that statute, because it's neither a newly discovered evidence nor is it a new rule of constitutional law. Unable to file a successive challenge under 2255, Mr. Jones instead looked to 2255E, the savings clause, which provides that a federal prisoner may file a petition for a writ of habeas corpus under section 2241 if and only if the 2255 motion is inadequate or ineffective. And he argues that it would be inadequate or ineffective because he can't even bring a successive challenge. Now, on review of that new argument, the district court ultimately dismissed his habeas corpus petition for a lack of subject matter jurisdiction, and then ultimately the Eighth Circuit affirmed the dismissal of the lower court. And that then led Mr. Jones to file a writ of certiorari up the Supreme Court wanting review of his case. And the question for Supreme Court review was whether the limitation on second or successive motions makes section 2255 inadequate or ineffective, such that the prisoner may proceed with a statutory claim under section 2241, which is a writ of habeas corpus. And in a 6-3 decision authored by Justice Thomas, the court held that it does not, so they ruled against Mr. Jones. Now, many people commenting on this decision are trying to say that the Supreme Court is holding that an innocent person must remain in prison without any remedies whatsoever, even if they allegedly are innocent, even under new Supreme Court precedent. But that's simply not true, because 2255H still leaves open the door for successive challenges. And to them, I would say, well, then why don't you review the constitutionality of 922G for nonviolent felons, analyze it under the Second Amendment, and ultimately find that 922G is a constitutional question, and that constitutionally it is a violation of the Second Amendment. That would then open the door for Mr. Jones to go back in and do that successive challenge that the dissenters, the liberal justices like Sotomayor and Kagan and Jackson, they are saying that this is wrong, that an innocent person is potentially remaining in jail. So I would then say, well, why don't you review 922G1, this nonviolent impossession of a firearm, find that it's unconstitutional under the Second Amendment, and permit him to bring a new challenge. So again, a really interesting case, a complicated procedural case, but it deals with nonviolent felons in possession of firearms, someone who didn't know that they were prohibited, purchased a firearm, and then ultimately is facing the federal consequences, even though the federal law is a violation of the Second Amendment. And again, it's going to be interesting to see maybe if these judges keep the same energy when they go decide if they want to grant review of these nonviolent felon possession cases that are currently pending before them. So again, interesting. If you have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.